Hi guys, Lisa Figueroa here, board certified criminal defense attorney in Florida. I'm here to talk to you a little bit about Bortlen Henry, who's a co-defendant in the YNW Melly case. Recently, because we've been focusing on Alicia Andrews, on the same date that Alicia Andrews was supposed to be sentenced, Bortlen Henry actually had a hearing on a motion to modify his sentence. If you heard, he had taken a plea back in September, pled out to 10 years, but also had some other charges, tampering, that were related to the case with YNW Melly. Now, apparently, shortly after he pled, there were a couple of things that were interesting about it. His attorney filed a motion to see if they could modify or correct the sentence, because after he got sent off to the Department of Corrections, he's in prison, and then he realizes that his out date, the date that he's scheduled to be released, is different for the two cases he pled to. So he actually is going to end up being there longer on the less serious case than the one that he pled to that gives him 10 years. So his lawyer filed a motion to modify that. And what's interesting is that no one really paid attention to this. There's no media reports about what happened in court that day. However, it was a Zoom hearing. The court denied their motion, and this was a negotiated plea. So usually the state attorney would be open to changing the sentence or stipulating to the amount of time served. But in this case, the court can only award the actual time. Like if he was only in custody on the tampering case for X amount of days, that's the only credit he could get, unless the state and the defense come to an agreement. So the judge denied that in this case, and we don't know the backstory. But if you heard his plea, when he pled, part of the condition of his plea is that he do a proffer. And a proffer is typically a statement that you give where you're protected as long as you tell the truth, and you can't be charged with anything that you admit to within that proffer. Now the question is, just because he has to give a proffer, does that mean that he's technically snitching on Melly or anyone else? Well, it depends. And when someone has to give a proffer, the only requirement usually that the prosecutor will condition it upon, like make the agreement, that they have to be honest. Now, how they can prove whether or not you're being honest is a different story, but those are the terms. If they catch you in a lie, then whatever deal they may have in place could get thrown out the window. I was asked whether or not he can not say anything. Well, that is not an option, because if his plea was conditioned on the fact that he's going to give a proffer, the idea is when he sits down in a room, a closed room, with his attorney and the prosecutor and potentially any of the lead detectives in the case, he has to answer whatever questions are posed. He doesn't have a Fifth Amendment protection or right to remain silent. That's part of the condition of the proffer and the agreement, and that's what lets him hold on to his 10-year deal or whatever he agreed to. Now, his attorney has maintained that there is no intent for him to testify against Melly, and that might be the case. So we'll have to see. The prosecution may just think that they have a strong enough case against him that they don't need it. They also may feel that Melly, at the end of the day, may reach a resolution and not wish to roll the dice and go to trial again. It begs the question why the judge was not willing to correct or modify the sentence. While I don't know the specifics, I can say that it certainly would have been something that the court would likely have been inclined to do if the prosecution was on board. So the question is really, why weren't they? And just in general, I've had cases where when you plea a case concurrent, when someone has two cases and they enter a plea, and let's say they get 10 years on one and 5 years on another, but it's concurrent. It's not 15, it's just basically 10, and the 5 years is like free because it goes along with the 10. If it's consecutive, it's one sentence after the other. The bottom line is, if you plea to two different cases with two different amounts of credit time served, there's a potential, and in this case, there was a potential that he was going to end up serving more time, and that's why the lawyer filed this. Now, the lawyer should have known or noticed this in advance. I'm not sure if it was the same lawyer or if it was just an oversight. And so let's see what he put in his motion. So you see, it's a motion to correct or modify sentence. So correct implies that there was an error or some sort of mistake. Modification, anytime that someone enters a plea, you have 60 days to ask for the court to modify, to change it in some way. So it wasn't necessarily a mistake, but hey, we just realized this was not our intent, or we're asking the court to do something different. And so that's Florida Rule Criminal Procedure 3.800 B and C. So basically on September 9th, he entered a plea, and they lay out what he pled to. 10 years prison followed by 6 years of probation, and then it was going to be concurrent with the other case number. And they actually put the 2019 case number, and in that case he got 10 years with 1,340 days of credit time served, but in this case he got 707 days of credit time served. The claim the lawyer is making is that when he entered his plea, he fully thought that not only are his sentences going to be concurrent, they're going to be coterminous. Coterminous means that they end at the same time. So he's getting 10 years, but they're going to end at the same time. But just because something is concurrent doesn't mean it's coterminous. So he actually is going to, the way he pled to it, he's going to do more time on the less serious case than on the more serious case. And so that's why his lawyers filed this motion and say, hey, this was a mistake. He didn't know that at the time he entered the plea. Now, if he didn't know that and that was significant and that would cause him to, he could withdraw his plea. He could say, hey, judge, this was not the deal. This wasn't what I was expecting. I want to withdraw my plea. But that's unlikely because of he was looking at life. He's only getting 10 years. So it's rare that someone would want to do that or be willing to roll the dice when the only issue is a matter of a few days. And I get it that a day is a day, and that's one less day that he's not with his family, or one more day that he has to be in prison. And in this case, it's several more days. I think that the motion says 633 days. So it's a significant difference as far as the credit time served. So they filed a motion, and then a hearing was going to be had to see whether or not the judge would fix that and basically make both cases mirror each other. So they start and they end at the same time, and that way he would be released on the same day. It went to court and the judge denied it. Typically in these situations, I make sure that I discuss this with the prosecutor. I always need to know how much time served my client has on each case. That way, if there is an issue like this, I can talk to the state beforehand, and then we either stipulate to the time served, so that way the sentences are both concurrent and coterminous, or we negotiate it out to make sure it's a resolution that my client is okay with, because in this case, it clearly was a surprise to him that this difference. Either way, the judge said no, and doesn't look like they're going to move to withdraw the plea. The case still goes forward, and only time will tell whether or not he is or won't testify in Melly's trial. Now, there was some other talk about a trial coming up on the tampering cases, and why would he be going to trial on the tampering case? I don't expect, even though something is set for trial doesn't mean it's actually going to go to trial. So I would not expect any tampering case to be going to trial in January. So that's it on this. I was just surprised that I didn't hear anyone talking about it, and I wanted to just touch base. If I hear anything else, I'll update you guys. Please keep putting stuff in the comments if you want me to talk about anything else or react to anything, and we'll see you on the next video. Take care.